This video will help you in understanding various stages involved in resolving dispute between member countries of WTO. Before understanding about the dispute settlement process, we should know what are reasons for dispute among members. So, whenever there is a violation of trade agreement among member countries, there can be a dispute. Parties in a dispute normally are first, a complaining country, one who suffers due to violation of trade agreement. Second, a responding country, one who has violated a trade agreement. And then there is a third group of countries having same interest in the case and enjoy some rights. As per WTO organization structure, settlement of dispute between member countries is the responsibility of the dispute settlement body. Dispute settlement body consists of all WTO members and has the sole authority to establish panel of experts to consider the case, accept or reject the panel findings or the result of an appeal. It monitors the implementation of the rulings and recommendation of panel or appellate body, and also has the power to authorize retaliation when a country does not comply with a ruling. First stage in dispute settlement mechanism of WTO is consultation, which means that the countries in dispute have to talk to each other to see if they can settle their differences by themselves. Within 60 days of filing the complaint, countries should resolve dispute through consultation. If dispute is not resolved through consultation, complaining country can request to appoint a panel. Now, the next question is, what is a panel? So, a panel is a quasi-judicial body responsible for resolving dispute between members. A panel is normally composed of 3 and exceptionally 5 experts selected on an ad hoc basis. One must also know that there is no permanent panel and a different panel is composed for each dispute. Request for appointing a panel can be made 60 days after request for consultation. The second stage in dispute settlement mechanism is of appointing a panel. As shared earlier, if consultation fails, the complaining country can ask for a panel to be appointed. Responding country can block the creation of a panel once. However, appointment of panel cannot be blocked in the second meeting unless there is a consensus against appointing the panel. As per the guidelines, panel should be appointed within 45 days of request by the complaining country. Once appointed, panel gets 6 months to conclude investigations. The role of the panel is to help the dispute settlement body to make rulings or recommendations. The panel findings have to be based on the agreement cited in the complaint. The panel's final report should normally be given to the parties to the dispute within 6 months. In case of urgency, including those concerning perishable goods, the deadline is shortened to 3 months. Now we will try and understand how a panel works. So before the first hearing, each side in the dispute presents its case in writing to the panel. On the first hearing, the complaining country, the responding country, and those who have announced they have an interest in the dispute can make their case at the panel's first hearing. In the next step, all the countries involved in the dispute submit written rebuttals and present oral arguments at the panel's second meeting. Panel may consult experts or appoint an expert review group to prepare an advisory report in case scientific or other technical matters are being raised in the dispute. After listening to all the countries involved in the dispute, the panel submits the descriptive section of its report to the two sides, giving them 2 weeks to comment. This report does not include findings and conclusion. After the first draft is reviewed by the complaining and the responding country, the panel then submits an interim report, including its findings and conclusion, to the two sides, giving them 1 week to ask for a review. However, the period of review must not exceed 2 weeks. During this time, the panel may hold additional meetings with both the sides. A final report is submitted to the two sides, and 3 weeks later, it is circulated to all WTO members. If the panel decides that the disputed trade measure does break a WTO agreement or an obligation, it recommends that the measure be made to conform with WTO rules. The panel may suggest how this could be done. Finally, the report becomes a dispute settlement body ruling or recommendation within 60 days unless a consensus rejects it. Both sides can appeal the report. In case one or both sides are not satisfied with the panel finding, they can file an appeal with the appellate body. Now, before understanding how appeals are heard by the dispute settlement body, one must know what is an appellate body. So, an appellate body is a standing body of 7 persons that hears appeals from the reports issued by the panels in the dispute brought by WTO members. These 7 persons are appointed by the dispute settlement body to serve for a period of 4-year term. Division of 3 members is elected to hear each appeal. So, as informed earlier, if either side is not satisfied with the panel finding, they can appeal a panel's ruling. Appeals have to be based on points of law, such as legal interpretation, and they cannot re-examine existing evidence or examine a new issue. The appeal can uphold, modify, or reverse the panel legal finding and conclusions. Normally, appeals should not last more than 60 days, with an absolute maximum of 90 days. After the appellate body have submitted its findings, the losing members must follow the recommendation of the panel report or the appeals report, must state its intention to do so at a dispute settlement body meeting held within 30 days of the report's adoption. If complying with the recommendation immediately proves impractical, the member will be given a reasonable period of time to do so. If it fails to act within this period, it has to enter into negotiations with the complaining country in order to determine mutually acceptable compensation. For instance, tariff reduction in areas of particular interest to the complaining side. If after 20 days no satisfactory compensation is agreed, the complaining side may ask the dispute settlement body for permission to impose limited trade restrictions against the other side. The dispute settlement body must grant this authorization within 30 days of the expiry of the reasonable period of time unless there is a consensus against the request. In principle, the sanction should be imposed in the same sector as the dispute. If this is not practical or if it would not be effective, sanctions can be imposed in a different sector of the same agreement. In turn, if this is not effective or practicable, and if the circumstances are serious enough, the action can be taken under another agreement. Dispute settlement body monitors how adopted rulings are implemented. Any outstanding case remains on its agenda until the issue is resolved. This slide helps in understanding the time frame that is required to resolve a dispute by the dispute settlement body. So if there is no appeal, the dispute can be resolved within a time frame of 1 year. However, with the appeal, the maximum time will be 1 year, 3 months.